Imagine a world where rats, pigs, and even dolphins had their own lawyers, went to court, and faced excommunication or execution. Between the 13th and 18th centuries, France, Switzerland, and Italy prosecuted rats, pigs, and even weevils in formal courts, complete with indictments, witnesses, and defense lawyers. Some trials took place in secular courts for livestock accused of homicide, while others were held in church tribunals for swarms and pests, blending law, theology, and folklore in astonishing ways. Get ready to dive into the most extraordinary trials where animals face justice, argued by expert counsel, and sometimes even won. Number 1. We begin with the remarkable story of Barthélemy de Chasseneuil, a pioneering figure in the history of animal defense, whose legal career reached legendary status through his representation of the rats in the Diocese of Autun, France. In the year 1508, a devastating plague of rats was ravaging the local barley crops, leaving the population in despair and prompting the Bishop of Autun to take unprecedented legal action. The bishop appointed Chasseneuil as the official counsel for the rats, marking one of the earliest recorded instances of an animal being granted legal representation. Chasseneuil's first procedural maneuver centered on the concept of inadequate notice, arguing that the initial summons was insufficient because his clients were scattered across a vast and diverse territory. He demanded that every rat be properly informed of the trial, highlighting the importance of fairness in legal proceedings, even for animals. The court, adhering strictly to the formal procedures of the time, agreed to this unusual request and ordered the summons to be read from every pulpit in every parish of the diocese. When the rats again failed to appear, Chasseneuil introduced an even more innovative defense: fear for life. He explained that the journey to court was perilous, as local cats, natural predators, awaited to ambush his clients. Chasseneuil argued that no defendant, human or otherwise, could be compelled to attend a trial that posed a mortal threat, challenging the villagers to provide safe conduct. Unable to control the cats, the villagers effectively caused the indefinite adjournment of the trial, preventing the excommunication of the rats. This extraordinary case did more than protect rodents. It set a legal precedent that resonated decades later when Chasseneuil defended human Protestants in Merindal, applying the same principles of fair hearing and safe passage. The Autun trial demonstrates how early animal trials, seemingly bizarre, played a critical role in shaping the foundations of modern due process, ensuring that justice could not be circumvented by circumstance or risk. Kicking things off at number 2, we examine the extraordinary saga of the weevils of Saint Jean de Maurienne in France, a legal battle that spanned 42 years and became one of the most extensively documented examples of animal defense in history. In 1545, local wine growers filed a formal complaint against the weevils, who were systematically destroying their vineyards, threatening the livelihoods of multiple generations of families. The court appointed Pierre Rambaud as the weevils' legal counsel, and he immediately advanced an unprecedented argument rooted in theology and the Book of Genesis. Rambaud claimed that because insects were created before humans, they possessed a primordial right to the earth's vegetation, making them not criminals, but agents of divine will, fulfilling their God-given duty to eat, multiply, and survive. This theological argument reframed the trial as a debate over property rights, ethics, and divine mandate, emphasizing the intersection of law, morality, and religious reasoning. By the year 1587, the prolonged legal standoff led the human plaintiffs to propose a settlement. A tract of land called La Grande Face would serve as a reserved habitat for the weevils, intended to protect the vineyards in exchange for relocation. However, the new defense lawyer, Antoine Filial, rejected the offer after expert evaluation, declaring La Grande Face barren, rocky, and incapable of sustaining his clients. He contended that relocating to this wasteland would violate the weevils' right to life and nourishment, and accused the humans of bad faith. The case, remarkable for its combination of legal ingenuity, religious interpretation, and strategic negotiation, reportedly continued until the court records themselves were allegedly consumed by pests, leaving the final resolution shrouded in mystery. This extraordinary trial highlights the lengths to which human society has historically gone to balance property rights, moral responsibility, and legal fairness, even for non-human defendants, offering a fascinating lens into the evolution of jurisprudence, where animals could hold legal standing and negotiate rights, much like human litigants. Coming in at number 3, we explore the infamous trial of the Sow of Falaise in the year 1386, a striking example of the psychological and ritualistic dimensions of animal trials in medieval Europe. This pig was accused of murdering a 3-month-old child, and the ensuing legal proceedings provide a vivid demonstration of how society sought to reassert moral and social order through symbolic acts of justice. After being formally provided with an advocate and found guilty, the sow was treated as a moral agent, dressed in human clothing, including a jacket and breeches to signify her participation in the legal system and her responsibility for the alleged crime. She was then paraded through the streets of Falaise and executed on a gallows in the town's market square, transforming a tragic event into a public and ritualized legal spectacle. The executioner received a specific payment for a new pair of gloves, a practice intended to absolve him of sin or guilt associated with taking a life, further emphasizing the moral and ceremonial aspects of the trial. Additional measures, such as providing human equivalent rations to the sow while in custody, reinforced the legal fiction that the animal was a fully accountable defendant, deserving procedural fairness before judgment. By mirroring human criminal proceedings, the trial allowed the community to process trauma, re-establish social hierarchy, and deliver justice in a structured and formal manner. The case of the Sow of Falaise demonstrates how medieval legal systems extended notions of accountability and ritualized punishment beyond humans, illustrating a fascinating intersection of law, psychology, and societal norms. The trial's meticulous attention to procedure, attire, and ceremonial detail underscores how early animal trials were more than curiosity. They were instruments of moral and social cohesion, reflecting the intricate ways in which law, culture, and symbolism intertwined in medieval Europe. Landing at number 4, we turn to the fascinating case of the beetles, or Inger, of Bern, Switzerland, in the year 1478, which provides one of the most theologically intricate examples in the history of animal trials. The community, desperate to save their crops from destruction, brought the beetles before the Bishop of Lausanne, seeking divine and legal intervention to protect their harvest. Representing the beetles was the advocate Jean Perrodet, who mounted a compelling defense grounded in the belief that his clients were God's creatures and thus inherently entitled to the fruits of the earth. Perrodet invoked the hierarchy of the natural world, arguing that the beetles were simply fulfilling their ordained role within the divine chain of being. The prosecution, however, responded with a uniquely theological counterargument, claiming that the Inger were imperfect and unclean because they were not explicitly mentioned among the animals saved by Noah on the ark during the Great Flood. According to the prosecution, the beetles had survived by secretly sneaking aboard as illegal stowaways, and therefore held no rightful claim to human crops or divine protection. The bishop ultimately agreed with this reasoning, formally excommunicating the beetles and commanding them to decrease and depart from the region. This case highlights how medieval animal trials were not merely legal spectacles, but also arenas for intense theological debate, where the status of a creature in God's creation could determine its legal and moral rights. It underscores the fusion of law, religion, and morality in early jurisprudence, showing how every aspect of creation, from humans to insects, could be subject to legal scrutiny and spiritual judgment. Coming in at number 5, the case of the Rooster of Basel in 1474 presents one of the most striking examples of legal panic in the medieval imagination, where an animal was tried not for tangible harm, but for the possibility of supernatural evil. The rooster was accused of laying an egg, an event so extraordinary that it triggered widespread fear across the city, as people believed such an egg could hatch into a cockatrice, a mythical serpent with a deadly gaze. The prosecution argued that the rooster, by this act, had become a vessel for demonic intervention, effectively committing a crime against nature. The bird, despite being provided with legal representation, faced an impossible defense due to the overwhelming moral panic surrounding the case. Ultimately, the rooster and the egg were condemned and burned at the stake in a public ceremony at Kohlenberger, turning the trial into a powerful spectacle of medieval fear and ritualized justice. This case demonstrates the symbolic function of animal law during the period. Animals could be punished not for their actions alone, but for the potential consequences their existence represented within the cultural and moral imagination of the time. By framing the trial around sorcery and unnatural behavior, the city of Basel reinforced social norms and religious beliefs while showcasing the extraordinary lengths to which medieval courts would go to control perceived threats. The trial exemplifies how legal systems often operated as instruments of public order, moral instruction, and symbolic retribution, transforming a simple rooster into the focus of a judicial and communal drama. Landing at number 6, we explore the trial of the moles of Stelvio in Italy in 1519, an extraordinary example of compassion and judicial fairness in medieval animal law. The local community had brought charges against the moles for damaging fields, yet the case unfolded in a way that acknowledged the vulnerability of these creatures while still addressing human concerns. The advocate for the moles petitioned the judge for safe conduct during their banishment, explaining that immediate removal would expose the animals to mortal dangers from cats, dogs, and other predators. Demonstrating remarkable empathy, the judge granted a 14-day reprieve for moles that were pregnant or still in infancy, explicitly instructing that these vulnerable individuals be allowed time to give birth and get their affairs in order before leaving the district. This decision highlights that, while these trials often involved creatures typically labeled as pests, they occasionally resulted in tangible protections for animals, revealing a judicial sensitivity that extended beyond mere symbolic gestures. By balancing the interests of humans with the rights of animals to life and safety, the Court of Stelvio illustrates the nuanced application of law in the medieval period, where ethical considerations could temper legal authority. This case underscores how legal representation for animals was not purely theoretical, but could lead to meaningful outcomes, safeguarding life and welfare in a society otherwise inclined to harsh penalties. The moles of Stelvio remain a testament to the human capacity for compassion within formal legal frameworks, showing that medieval jurisprudence could accommodate fairness, empathy, and practical reasoning, even for the smallest and most vulnerable members of the animal kingdom. Coming in at number 7, the trial of the Savigny sow and her 6 piglets in France in 1457 provides an exceptional example of how medieval courts addressed the principle of complicity in animal crimes. The sow was accused of killing a 5-year-old child, and her piglets were found at the scene, reportedly covered in blood, raising questions about their involvement. The defense lawyer argued that while the piglets were present, they had not actively participated in the attack, emphasizing their youth and the influence of the mother as factors in their behavior. The court ultimately acquitted all 6 piglets, returning them to their owner, Jehan Bailly, establishing a clear application of the presumption of innocence, even within the context of animal law. This trial highlights the sophistication of medieval legal reasoning, showing that courts distinguished between principal actors and bystanders, applied standards of intent, and ensured that punishment was proportional to actual culpability. The Savigny case underscores the broader legal principle that justice required careful assessment of evidence and responsibility, a practice that extended to non-human defendants when warranted. By integrating nuanced judgments into trials of animals, medieval courts reinforced the legitimacy of the legal system, demonstrating that fairness and reasoned evaluation were essential even in extraordinary circumstances. Rounding out at number 8, we examine the fascinating realm of aquatic jurisprudence, where medieval courts extended legal authority to the creatures of rivers, lakes, and seas, using the Church's power of excommunication as a tool to regulate natural behavior. In 1451, a pile of leeches was brought to court in Geneva for allegedly harming salmon populations, and rather than facing mass destruction, the bishop issued a spatial order, confining them to a specific section of the lake. Historical records intriguingly claim that the leeches obeyed this decree, preventing further legal action and demonstrating a unique approach to animal regulation. Similarly, dolphins and other schools of fish were occasionally excommunicated by popes and bishops for interfering with fishermen's nets, a practice reflecting the belief that the oceans were a chaotic, lawless domain requiring spiritual intervention. By applying the same ecclesiastical authority used against human heretics, the Church asserted dominion over all of creation, from the highest mountains to the deepest trenches of the sea. These trials reveal the remarkable scope of medieval animal law, encompassing not just land and air, but also aquatic environments, and illustrate the creative use of legal and spiritual tools to enforce order. The excommunication of dolphins and leeches underscores the interplay of morality, authority, and environmental control, demonstrating that legal representation and oversight could extend even to creatures far removed from human society. These medieval animal trials may seem absurd to us today, but they reveal a deep commitment to law, order, and justice, where even a pig or a weevil could be held accountable in court. By putting animals on trial, society sought to restore the natural and moral order, enforce compliance, and remind humans that every action has consequences. These bizarre yet meticulous proceedings laid the groundwork for modern ideas of animal rights and legal standing, showing that justice was once applied to all living beings, not just humans. If you enjoyed this journey through the strangest legal cases in history, make sure to like, comment, and subscribe for more fascinating stories. Thanks for watching.